Hello, I'm Steven Roy Goodman, host of Higher Education Today, a production of the University of the District of Columbia. Welcome back to the education program that connects you to contemporary issues, people, and institutions involved in the world of higher education. Today we'll be talking about a new policy that eliminates special notations or flags for aspiring law students who are permitted extra time on the LSAT. Shelley Broderick is Dean of the UDC David A. Clarke School of Law and host of Sound Advice, a long-running show on UDC-TV about legal issues. Matthew Kaplan is a UDC Law Student who successfully challenged the Law School Admissions Council's policy on flagging extra time accommodations for the LSAT. Matthew is a 2005 graduate of Oberlin College. Welcome to both of you.
Thank you.
It's great to be here.
Well, thank you both. Matthew, maybe if we could start with you.
Sure.
Since you're the star of the show, what happened in this case and how did you get involved and
Sure.
how did this involve the Justice Department?
Well, so I graduated from undergraduate in 2005. I was working in Washington for a number of years, and I decided I wanted to go to law school. I was working on public policy issues, and then I applied through the LSAC to get accommodations, which I had received these accommodations since I was 7. And initially they denied me. I thought it was a mistake. I thought this couldn't be real. And so then I found an attorney, hired an attorney. We appealed that decision, and then they denied that, and then we went directly to the Department of Justice, who eventually accepted my complaint and intervened on my behalf and a number of other people's behalf to enforce the federal law to prevent this type of discrimination.
And so the discrimination in your view is that you could take the LSAT with a special flag or not take the LSAT at all?
Well, for me, actually, I was denied accommodations entirely. And so, ironically, I wouldn't have even been given the flag. I would have been given no accommodations. They gave me a computer to use to write my essay at the end, which is ungraded. So not only did we win in terms of providing accommodations to people, but also the flagging policy was ended as well.
And how did you involve UDC, and how did UDC get involved?
Well, so I was trying to figure out how to get into law school. I knew that I could not take this exam while they were breaking the law. I knew that my first act as a lawyer could not be subjecting myself to an illegal discrimination. And so I actually went on a little bit of a road tour and introduced myself to law schools from all over the place. And everyone was very accepting, but the UDC was the only school that was willing to take a look at my application without the law school admissions test. And they took a risk, and I know that them and I are very excited that it worked out.
Well, and speaking of the risk, Shelley, if you could say a word or two in your role as dean, did you personally intervene in this case and say, I like Matthew and I want to take a risk on him?
The director of admissions, the fabulous Vivian Canty, I think she's the best in the business, brought his file to me. The committee had voted unanimously to accept him. We don't normally accept anyone without the LSAT. You're required, the ABA requires that you have a test, have the students all have to take a test, and the only national test is the LSAT. So this was an exception. And they brought the file to me, and I read every word of it. And as he said, he was accommodated from the age of 7 on and did extraordinarily well. He had spectacular recommendations from his faculty members at Oberlin. He was working on Capitol Hill doing legislative policy work and understood that he needed a law degree to ratchet his abilities up in that. And it was clear to me he would absolutely be successful, and that test should not be a barrier. You know, we also pride ourselves on caring very deeply about this, and one of our faculty members was the principal author of the Americans with Disabilities Act. How could I turn Matthew down? It was a no-brainer. He was an easy guy to take.
But have there been other instances when maybe it's Matthew who's not as good as Matthew? Maybe there's a student 2 years ago who is not quite as good as Matthew, and what happened in that case?
Well, the spectacular thing about Matthew is that he had the guts to do this. Mm-hmm. Everyone else towed the line and took the test either without accommodations or took the test with accommodations, but let the flag come to us. And so he's the only one who had the guts to do what he did. And I admired that.
Well, what, can you say a word or two about how it works when a flag comes to you as an institution?
So institutions, when you find out that a student needs accommodations, you know, let's face it, human nature is what it is. So every admissions committee looks and sees, well, here's a guy who looks like he's got a lot of talent and skill and could be successful. But it's going to cost us a lot of time and money and resources because every single test he ever takes is going to have to be specially administered for 3 or 4 years if they were in the part-time program. And so human nature is that if you're looking at 2 identical sets of scores and kinds of situations, you're more likely to take the one without the disability. So that flag raises a red flag for every institution. Even though your heart is pure and you want to do the right thing, I think there's no question in my mind that it has kept people from being accepted.
But then why did we wait until this case? With all due respect to you and your fellow law school deans around the country, if your hearts are in the right place, why couldn't you simply take more students, let's say, who are in wheelchairs, rather than waiting for somebody to say you need to take more students in wheelchairs?
Well, don't get me wrong. We take lots and lots of students with disabilities. We have had students in wheelchairs for 25 years. We have had students who are blind. We have had students who are deaf. And we have had countless students with various other kinds of disabilities. So I didn't feel like I needed to go after LSAC because I think our school is very, very committed to not discriminating against, notwithstanding the flag, they get a full hearing and are accepted at our school. But I think other schools, you know, it's a cost-benefit analysis. You know, this might be a great candidate, but I've got lots of great candidates who aren't going to cost me a lot of money in terms of making sure that they can have all the accommodations they need.
Fair enough. Well, maybe if we could ask both of you about the issue of the LSAT versus the SAT and the MCAT. So for viewers who may not be familiar with this, about 10 or 12 years ago, the SAT folks finally got rid of the flags. Now the LSAT folks are getting rid of the flags. But if you want to be a doctor, you still get a flag on the MCAT if you take the exam. So maybe if you could comment about that a little bit.
Sure. Well, when I actually originally took the SAT, I was flagged. And in an ironic way, I was flagged when I was applying as well because I didn't have the LSAT. So, and the MCAT, my father actually is a doctor, and he went through some of the similar challenges when he was getting into a medical school. And actually wasn't accommodated until at the end of medical school, after he had already gone through this process, only after he had gotten a PhD and became a nationally recognized researcher did he realize that he actually had this disability. So.
Wow. That's really interesting. So this has really affected your family in 2 different generations now.
Yes, it has. And originally when he only found out that he had dyslexia, same profile as me, when he was at a national conference. He was at a national conference sitting next to a nationally recognized neuropsychologist who was listening to his story and said, well, you probably have dyslexia. And it was only then that he was able to go to the medical board and make his case after he had already been in medical school. And so, and they denied him initially. They said, we're not going to give you accommodations. So he had to actually do something, not nearly as drastic, but he had, and this was before the Americans with Disabilities Act, he had to hire an attorney to make his case.
But what about your dad today who doesn't have the resources to hire a private attorney who wants to be a doctor? What does that person do?
Well, the MCAT flags and the medical bar examiners actually have a similar action a number of years ago. But you're right. If a person is wanting to take the medical exam, then they're flagged. They're put into a different pile. They're treated differently, and in my opinion, that's discriminatory.
I couldn't agree with you more, Counselor to be. You know, I think the issue is there's this concern that anyone who gets more time to take a test is getting some unfair advantage. And all the testing shows that that's not true. So if you give me more time on a test, I only know what I know. I don't need more time. I'm actually a very fast reader. More time is only time for me to start second guessing myself and make mistakes. It doesn't benefit me. I don't do better. More time for someone who processes information differently and needs more time to do so effectively, someone with dyslexia or other kinds of disabilities like that, does benefit them significantly. All the science says that. Similarly with the MCAT, it's not a speed test. You know, your ability to process information as a doctor doesn't depend on, speed is not the deal. That's, it's capacity to work with the material and the information. And so since they're not testing speed and don't need speed to be a doctor in that way, it doesn't make any sense, and it should fall.
But that raises the question then is, what's the correlation between a student taking the LSAT and how they're doing in law school, or the GMAT and how they're doing in medical school, and why do we have these national exams then?
Well, the LSAT is a good predictor of how you'll do in your first year courses. And actually, your first year GPA is the best predictor of how you'll do on the law boards. But it's nothing to do with subject matter knowledge. You know, they're not testing you in the LSAT what you know about the law. They're testing your ability to reason and use logical analysis and read with proficiency and that kind of thing.
But the MCAT is different. The MCAT does measure subject matter expertise. So what's the public policy rationale for one versus the other?
It doesn't make sense to me because, again, it's not about the speed for the reading. So you either have mastered the subject matter area and you need more time to express that. What's wrong with that?
Well, what would the folks from LSAC say if they were here right now?
We give. Uncle, I think, would be the operative term. Uncle.
Before they said uncle.
Oh.
Before they said uncle, what would they say?
We have the free speech right. You know, our free speech rights are being trammeled by Matthew Kaplan and his crew. We have the right to tell law schools that students have disabilities. I'm still scratching my head about why that would be important. And my guess is lots of people at LSAC, and I know many of them, I have a lot of friends there, are pretty happy about this result.
Fair enough.
Change is difficult.
Well, speaking of change, when we're talking about the issue of change, let's say we're moving in the direction of looking at what the correlation is between a student going into a program and their success in the program. And there's been a kind of anti-testing movement around the country in a whole host of ways. Some people argue that what happens with that is that only wealthy students benefit from that because they're the ones who can afford a psychoeducational evaluation. And then all of a sudden they're advantaged in the admissions process, whether it's the undergraduate admissions process, the law school admissions process, or the medical school admissions process. How would you counter that?
Well, the first thing I'd say, too, is I think that this discrimination goes back to the age of 7 or 8, because the only way you get accommodated later is if you have this long history. So you have to be an activist. Your parents have to be an activist when you're 7 or 8 or 9, and you're not learning how to read. So this is really a type of discrimination, I think, that goes on very, very extensively throughout someone's life.
Well, and I think the data show that actually, yes, rich people and affluent people have the wherewithal to go get the testing done and then get accommodated, whereas poor people don't have that wherewithal. But the other thing is that a lot of minorities and poor people aren't asking for accommodations. They don't know about it. They haven't been informed about it. They don't understand they have that right to do that. And so the whole thing, we need a whole lot of work to get this information out and understanding of what your rights are and how you should proceed if you have disabilities. We've got a lot of work to do still.
And I think that that's the exciting part of this case is this is a conversation about what people's rights are. Many people don't know that they have the right and to ask for accommodations. And now, in this case and in others, hopefully more people are aware of those rights.
Well, you know, and this is so in our wheelhouse. We have a nationally recognized, we have an outstanding clinical program here at the law school, ranked in 7th in the nation for top clinical programs. And one of our stellar, long-standing clinics is a juvenile and special education clinic. We know that kids with special education needs, whose needs are not met, end up in jail. It's that simple. They end up dropping out of school, getting employment where they can get it on the street, and falling afoul of the criminal justice system. And so if we're smart as a society, we will make sure that those kids get the help they need to stay in school and be successful in school, and spend that money early on and on the front end instead of on the back end, where these kids' lives are ruined. So,
fair enough. Can we talk a little bit about the federal law versus local law? Mm-hmm. What's the difference?
The Socratic movement, the Socratic, go ahead, Matt.
Well, so the way that this case,
that's what professors do.
We'll use this case as an example. So the case was originally brought in Northern California under state law, and the state of California has a stronger anti-discrimination policy, arguably, than federal, even the ADA. The Law School Admissions Council removed this case to federal court. Once they removed the case to federal court, at that point, the Department of Justice intervened in the case so that to enforce the federal anti-discrimination law and to make sure that whatever agreement was reached in California would have national impact. And so there really are these two different policies, or two different anti-discrimination laws that kind of overlap, and in this case to result in the policy that's been changed.
Well, that's ironic if I understood what you just said, because normally what people want to do is not go to federal court if they're the defendant. So the irony here is that LSAC said, well, let's go to federal court, and then the big bad Justice Department came in and helped out. Right.
And that's where they used me and other individual plaintiffs, naming them as indicative of the cases that they wanted to enforce in federal law.
But that may have changed the whole case, because I mean, think about, from where I sit, you know, I'm a reform lawyer as well, that that my understanding is that what happens in a lot of these cases is that the clinics, various clinics, get involved, and they have far fewer resources than the Justice Department.
Absolutely. And when the Department of Justice intervened and decided to start investigating my complaint, indescribable how excited I was, because you get to this point in this fight and you realize that the Department of Justice agrees with you and thinks that this is a discriminatory policy and is going to fight to change that policy. That was a moment unlike any in my life.
Thank you, Eric Holder.
Well, what about a person from another country? Let's say somebody applies to, I know we're talking about the LSAT, but let's say we're talking about another school. What rights does somebody have from another country who is applying with our admissions process in the U.S.?
For accommodations?
Yeah.
Well, I don't think it matters. They don't look at your citizenship. This is for a place in a law school in the United States, and that has to be a fairly administered test no matter where you're from.
And the LSAT actually is administered in a number of other countries.
Yeah.
I saw a little bit of traffic on this about some of the Canadian law schools. Some of them use the LSAT, and they had said they were in a similar position. They said, well, this is clearly, flagging clearly seems to be a discriminatory policy, but we really don't have any choice. The law schools didn't have any choice. They were given this test, and either they accept it or they don't. And so even under Canadian law, now that the Law School Admissions Council has to stop flagging, this has impact all over the world, because the LSAT is administered in a number of countries.
But why wouldn't a law school say, well, let's take the GRE, for instance. Like, Shelley, you're the dean. Why couldn't you say, we don't like the LSAT anymore as an exam? If I understand this correctly, the ABA says you need to have an exam, but it doesn't say you need to have the LSAT.
That's correct.
So why couldn't you say, let's use the GRE?
Well, you know, Rutgers got in trouble last year. It was learned that they had accepted a number of people based on their GRE, which is the graduate record exam, and not the LSAT. And the fear is that schools are doing that as a way to take people they think are talented, but who have low LSATs, and schools have to report their LSAT means and medians and so forth. And so that would take them down in the U.S. News and World Report rankings. And so they don't want to report low LSATs, even though they believe that some folks with low LSATs have the ability to succeed and go forward and pass the bar. And so the fear is that they're scamming US News and World Report to get higher rankings by using these other tests. And so, law schools are very, and that school was fined for doing that because they didn't report it sufficiently. So you can do it, but it's more work, it's more effort, it's having to think about it, it's trying, we're lucky because we've always taken a very holistic look at every application. We do not just look at numbers. We require students to write an essay on an injustice that they experience because we want to see how they think. If your injustice is that you got a speeding ticket due to a speed trap, not that interested in you if that's your idea of an injustice in the world. You can only imagine what his injustice was and how compelling a case he made even before going to law school. The big scandal right now is that schools want to, with the plummeting applicant pool to law schools nationally, schools are trying to maintain their US News and World Report rankings, and so they're taking fewer first-year students to keep the LSAT and GPA high. Right. But then they're taking vast quantities of transfer students. So the big dogs, the top named schools, aren't taking first-year students because they have to report, they don't want a diminished LSAT number in US News, right. But they're taking transfer students because you don't have to report the LSATs of transfer students. So you go to another school, you prove yourself with outstanding grades, that school has taken the risk on you and right. believes in you and supported you through the first year, and then the big dog schools take you. Georgetown took 122 transfer students last year. Well, that's the whole law review for a lot of lesser known or lesser brand schools. And there's a lot of unhappiness in the land, and Georgetown's not by any means alone. Schools are doing it nationally. There's a pecking order.
Right. And from my point of view, it really is the US News that drives this whole conversation, and in the end, ironically, results in a discriminatory policy and preventing people that would be really good lawyers or doctors or whatever from entering the field, and that I think is very unfair, and it results in something that our society doesn't want.
Well, fair enough. We only have another minute or two left. What bits of advice would you like to leave for folks watching who
Sure.
are learning this and say, well, maybe my son or daughter needs extra time, what should they do?
Well, I think the biggest thing you need to do is when you're young, make sure as soon as you realize that there's some sort of problem, you've got to be your own advocate. In elementary school, in middle school, in high school, you've got to be your own advocate. You have to develop a long history of accommodations so that when you go to the SAT, when you go to the LSAT, you can show them this background. And to be honest, becoming your own advocate has been a good training ground for me, at least, to becoming a lawyer as well. And
do you think you would have been a good advocate without your dad having had a similar experience?
I mean, I hope so. I have to say that my parents standing beside me and telling me that you're different, but that's okay, and you're still smart and you can still perform, that really made a big difference in terms of my ability to really perform. And so that I hope that other people that are going through this process and they're 7 and they can't read, they say to themselves, maybe there's something different, and they have to think about how to become a better reader so that later on that they could perform in the ways that they want.
And Shelley, anything that you'd like to add from the law school perspective?
Well, I just want to, really all I want to say is congratulations to Matthew for all the courage that you showed in fighting this good fight. And in pushing it all the way to success. Good on you. Thank you.
Well, congratulations to both of you. If you would like additional information about Dean Shelley Broderick, Matthew Kaplan, or the UDC David A. Clarke School of Law, please visit law.udc.edu or dfeh.ca.gov/consent decree in dfeh v.lsac.htm. If you have comments or suggestions about higher education today, please send an email to our viewer mailbox at highereducationtoday@topcolleges.com. Thank you for watching. We will continue to bring you quality discussions about important matters in today's college and university world. Please join me again for another edition of Higher Education Today. I'm Steven Roy Goodman, and you've been watching Higher Education Today.